So, we have the pleasure today to have Derek Graham present valuable information regarding Medicaid estate recovery in Ohio and how it affects disability benefits after death. Medicaid estate recovery is often an unknown, very often an unknown, but it's very important for estate planning, specifically for the disabled community who have Medicaid healthcare or have had it or waiver services. Derek is an attorney who works with families who have loved ones with developmental disabilities and will give you insight into his journey himself. So please welcome Derek and sit back and enjoy the ride.
Thank you, Dorinda. I really appreciate that. First of all, I really appreciate being asked to come here today, and I want to applaud this group for putting together this series. What I do in my day job is like Dorinda mentioned, I'm an attorney. I work with families who have loved ones with developmental disabilities. And we hear, just like a lot of you, we hear a lot of myths, concerns, partial truths. And one of the ones I hear frequently that does always upset me is, my loved one with a developmental disability can't get a job because it will do this or because it will do that. Um, Not everyone has the ability to work, but those that do absolutely should, in my opinion. And the fears around employment are almost always, you're almost always able to debunk those when you dig into it and start talking about what's really going on. So I really applaud this group for putting together this series. And today we're going to talk about a topic that is Medicaid estate recovery. And we're going to talk about Medicaid estate recovery, and then we're going to wrap in other issues that touch on Medicaid estate recovery in different ways as well as the presentation goes on. I really like questions, so if you have questions, please make sure you put those in the chat, and we'll stop periodically, see what's there. Most of them will probably be answered at the end, so sit tight if you don't get an answer right away. But if it's something that's directly on point, don't hesitate to ask. Now, when I was putting together, I was talking to Lisa. This is what I was going to pick on Lisa for if she had stayed. They had mentioned that they wanted me to put together a little slideshow or presentation, but they wanted to run through it and make it match and be accessible. So I put together a slideshow and sent it to Lisa, and we had our wires crossed because I thought she was going to move it on to background and other things like the rest of these really fancy slides you've seen up till now. And turns out that's not the case. So my slides are the most basic, boring white slides you'll ever see, but that's okay. So that's what I was going to pick on Lisa for if she was still here. So today's topic is Medicaid estate recovery. Throughout these slides, you're going to see MER. And I know we have a huge acronym problem in our developmental disability system, and I try to avoid acronyms. But when you're dealing with PowerPoint and trying to make stuff fit, acronyms can be really useful. So the only acronym I'm going to ask you to remember for today is MER. And I'll try to catch myself as I use other acronyms as the presentation goes on. So what is MER? What is Medicaid estate recovery? First of all, everyone thinks, and you hear people say all the time, that the state of Ohio is going to take this asset, or the state of Ohio is going to come after assets in certain situations. Medicaid estate recovery is not actually something that's born out of state law. It's part of federal law. And specifically, it's a federal mandate. And what that means is in order to accept Medicaid funds and the Medicaid funding portion that's provided by the federal government, the state of Ohio, it is mandated that they pursue recovery of certain Medicaid assets at different points in time. And when I say recovery of Medicaid assets, recovery of assets that otherwise belong to someone that received Medicaid. The theory and the speeches behind this when it first was developed, and I'm not at all saying I agree with this, but the theory behind this was they wanted to make Medicaid for individuals that had assets more of a grant or a loan than an entitlement of here it is, you can have it. And so the thought was some individuals might need to qualify for Medicaid, and we might need to provide Medicaid assistance, but if they have certain assets that could pay for that coverage, we want to recover those at different points in time. So MER, Medicaid Estate Recovery, it starts as a federal mandate. The state of Ohio as a state has no choice but to implement Medicaid Estate Recovery. They wouldn't have the ability, even if we wanted to pass a state law saying we're not going to participate in Medicaid Estate Recovery. Now, Once it's implemented by the states, they do have the ability to expand what all is covered under Medicaid estate recovery. And the last time I heard, I think it's 37 or 38 of the states have expanded in some way or another how and when they recover assets as part of Medicaid estate recovery. And Ohio is one of those states that has expanded. So that means they have implemented what the federal law requires, but they have also added additional things beyond what federal law requires that they are going to seek recovery from. And so but before I get into the specifics, and I know you're sitting there thinking, well, what is it, Derek? Sure, it's a federal mandate, but what does that mean? And I'm going to get into that in just a second. But anytime I'm giving a presentation that is in large part based on Medicaid, I always like to just stop and review a little bit of the history of Medicaid, because a little bit of the history of Medicaid helps me keep into perspective why certain things are the way they are, even if the way they are, in my opinion, is broken, which in some ways it is. So let's talk about the history of Medicaid. If you've heard me talk before, you may have heard this before. I like to read history books. I enjoy reading about history, and the Medicaid as a program has a very colorful history to it. So in 1965, that's when the federal government was basically recreating Social Security. So they had something similar to Social Security up to that point, but they were reimagining and recreating Social Security. And in 1965, as they're reimagining and recreating Social Security, a group of states, Ohio being one of them, went to the federal government and said, Social Security sounds like a great program. Medicare sounds like a great program. But what's really expensive for us states is the cost of paying for the care. And it makes your skin crawl to say this word, but paying for the institutions where we place individuals with developmental disabilities. That's really expensive. Can we add that to something Medicare can pay for? And the federal government's response was no, we don't want Medicare to pay for the cost of institutional care. We don't want Medicare to pay for the cost of health care for everyone in a facility like that. And so instead of adding this to Medicare, they carved out and named something new and called it Medicaid. I would love to meet the person who decided, let's name it Medicaid, so that everyone for the end of time can be confused about Medicare versus Medicaid. But they gave it a terrible name. They called it Medicaid. And Medicaid, as it was originally constructed back in 1965, it can only be used to pay for two things: placement in a 24/7 facility. And unfortunately, back then, that was more of an institutional setting, as much as you hate saying that. And health care of someone who qualified for that placement. And so we know that the classifications for those placements were individuals who were age, blind, disabled, met these criteria. And so Medicaid starts, and when it does start, the federal government said, we'll pay for part of it, but you states have to pay for part of it. And so I'm preaching to the choir when I start talking about the match and those kind of things. And basically that means for every dollar that's spent on Medicaid, especially traditional Medicaid or original Medicaid, part of that money comes from the federal government, part of it comes from the state government, part of it comes from local government, depending on a variety of different factors. Okay, so how does all this factor into where we are today? So you have this traditional Medicaid that starts back in 1965. It does, I guess you could say it does what it's supposed to. It pays for that level of care for individuals. It pays for health care that qualify for that level of care, for individuals that qualify for that level of care. And then as time goes on, you get into the 70s, and there's a lot of frustration because there's still a lot of voids. The voids are, you take somebody like my family, and I'll talk about my family a lot today. So I'm very happily married. I have 3 daughters. My oldest daughter was born with Down syndrome. And so that threw me into the world of being the parent of someone with a developmental disability. She's 17. She'll turn 18 next March. And so not only do I, represent families going through this, I go to sleep every night horrified for the same reasons that some of my clients are, just because you're nervous about what will happen. Now, I always tell clients, of my 3 daughters, the one that keeps me up at night the least is the one with Down syndrome. It's the other 2 that I worry about more, but that's just being a parent. All right, so going back to the 70s, Medicaid is doing what it's supposed to do, but families go back to Medicaid and say, there are problems with this. Take a family like the Grahams. Derek is an attorney, that's his job. His wife is a teacher. Megan ends her involvement with the school system. What are they supposed to do? Or what are the parents going to quit their job? Are they going to be able to afford to privately pay for caretakers? How does all this work? The states wanted the federal government to open up some of the purse for Medicaid and allow them to use some of the Medicaid funding to pay for additional supports. The federal government said, no, we're not going to change traditional Medicaid, but we will add a section to it. And that's what they did. They added provisions to the existing Medicaid statute that said, okay, states, we will let you use funds otherwise allocated for paying for the placement of someone in a 24/7 facility. And we will waive the requirement that the person be in the facility for you to receive those funds if the funds are used to promote that individual's independence. And that then in the early 80s was the birth of the legislation that creates Medicaid waivers. And that's why I always tell clients, when you're talking to clients about waivers, the term waiver is very confusing. Nobody ever really knows what's being waived and why do we call it a waiver. And that's what's originally, now there's some other things that came along after, but what was originally being waived when they created that legislation was the requirement that the person live in a 24/7 facility. And so that legislation happened in the 80s. Then in the 90s, we overhauled Medicaid again in a major way, in what honestly is a very confusing way. And that was in 1993 with what's called an OBR Act, and that means Omnibus Budget Reconciliation Act. So as the federal government was passing its federal budget, as you know from all the news stories about shutdowns and those kind of things, excuse me, they put all kinds of things in the budget that don't really apply to the budget. But in 1993, when they were doing the budget, they put all kinds of things into the budget that affected Medicaid and that affected how Medicaid operates. It's one of the biggest changes to Medicaid. Well, it is the biggest change to Medicaid since it was originally created in 1965, which has always been ironic to me, up until, I guess you could say, some of the expansion Medicaid provisions are a bigger impact. But up at that point, that was the biggest change or impact to Medicaid. And one of the things they said in 1993 when they passed this Budget Act, of all things, is there's going to be this federal mandate. And we are going to allow individuals with qualifying disabilities who need to tap in and utilize Medicaid resources to do so. But if those individuals have certain assets in their name or have resources in their name, one, they're not going to qualify. But if there are resources that are maybe exempt and they do qualify, we will want to recover what the Medicaid pays on their behalf later on, most notably at the time of their death. Not always the time of their death, most notably at the time of their death. So what is the purpose of MER? The purpose of it is just to recover tax dollars used for long-term care and home and community-based services. So when the state and the federal and local governments are paying funds towards the cost of someone's care, whether it's in a long-term care setting, home and community-based services, waiver services, if Medicaid is paying for it, they're going to keep track of it. And so again, in theory, the speeches behind all of this when it passed is they wanted to make Medicaid more like a grant or loan than an entitlement. I don't agree with that analysis, but that was the selling point used when this all came into place. So that's why Medicaid Estate Recovery came into existence, and that's my history spiel on Medicaid that helps us understand how we got here. Now, when we talk about Medicaid Estate Recovery, what does that actually mean? That means when someone who dies, I'll start with death. When someone dies, if they have assets in their name, then the government is allowed to come in and try to collect from their estate or collect from the assets they owned at their death an amount equal to what the government paid on their behalf during their lifetime. So here's something that surprises some individuals. When you receive services through Medicaid, or when you receive services through a Medicaid waiver, or sometimes in very limited circumstances, even Medicaid services like the MPAP program where it's paying for maybe some Medicare premiums, that kind of stuff. When you are receiving some of those services, The state of Ohio tracks what is paid on your behalf. And I can't tell you how often I sit down with a family in a conference room and we start talking about their loved one with a disability, and we start talking about the fact that they've been the recipient of Medicaid or Medicaid waiver. And the family will tell me, yeah, but they don't really use it that much, or it doesn't do much. It just provides, some transportation and pays some health care and that kind of stuff. And then when the individual with a developmental disability passes away, that's typically when we might reach out to the state of Ohio. And in some circumstances, have an obligation to reach out to the state of Ohio. And that's when we find out to the penny how much money was actually spent. And they don't guesstimate, they don't have like a daily rate. They will tell you to the penny how much money has been spent on an individual. They can give you an Excel spreadsheet that tells you to the penny how much money they have spent on someone who's receiving these services. They do track that. It all ties in, as our providers who have a very hard job, as they track all that and do their Medicaid billing, it all flows right on through in some software that's way above my head that ties it all together and tracks that so that the state of Ohio can tell you, exactly how much someone has received. All right, so what is being recovered? So you take someone that has an estate, and here, and admittedly, one thing I'll say at the beginning, Medicaid estate recovery comes up more frequently for people in the aging system than it does for people in the developmental disability system. In fact, tenfold. And so one of the problems we run into with Medicaid estate recovery is it's a system that has largely been designed around recovering funds from people that use Medicaid as part of the aging system. And so when you have people with developmental disabilities that fall into Medicaid estate recovery situations, it sometimes plays out in an unfair, or it might make you scratch your head and say, why would they structure the program that way? And you have to remind yourself, this is a system, the Medicaid estate recovery system was more built for individuals who are using Medicaid in an aging system than a developmental disability system. So what is being recovered? Basically, any asset a person had a legal interest in at the time of their death can be subject to Medicaid estate recovery. So if as I continue to age, I've had members in my family that have had, Alzheimer's. So let's just use me as an example. So as I age, if I were to, I hope and pray not, but if I were to develop Alzheimer's, and I were to have to live in a long-term care facility at some point, if I need that level of care. And at some point, I start receiving Medicaid, and Medicaid starts paying for that care. There are lots of reasons that I would privately pay for my care, and we'll talk more about this with some examples later on. I would privately pay for my care for a while, but if at some point I qualified for Medicaid and Medicaid started paying for my care, then when I subsequently died, some of my assets may not have been countable assets at the time I was receiving Medicaid. Or honestly, I may just not have told Medicaid about them. And when that happens and I pass away, they have the ability to come after those assets. They can come after real estate. They can come after assets that pass through probate. They can come after assets that pass without probate. And we'll talk about what that means in a second. They can come after bank accounts. They can come after my life insurance. They can come after trusts that I've created, and just about anything else. So the Medicaid estate recovery gives them a very broad range of assets they can come after when I pass away. And the reason they would be coming after them is because during my lifetime, I used and received Medicaid benefits. So let's talk a little bit more about what is being recovered. And before we do that, I want to break down a couple things to make sure we're all on the same page. Some people get very confused, and there's a lot of bad information out there. Some of these questions, if you plug them in and just ask ChatGPT, you will get the wrong answer. And that's true for a lot of Medicaid situations. AI has come a long way. I use it all the time, but it can really give you bad information when it comes to Medicaid. And that goes back to our history lesson, because at the federal level, they've created Medicaid in legislation and they've given states options. And so each state has to have a state plan for Medicaid and they have to make certain decisions as they're choosing which options to use. Then the state has to comply with all the federal rules that go with that option they selected. But in addition, the state's allowed to add their own state rules on top of it. And so you've got federal and state rules. And so it's really hard to get the right, accurate information on Medicaid, which is why it's, as far as AI has come, it is still not a great resource for people that are trying to specifically research certain Medicaid topics. And so one of them that you'll see all the time that is completely incorrect is you'll see things on the internet about how Medicaid estate recovery only applies to probate assets and it does not apply to non-probate assets. This is a very important distinction that I want to make sure we dispel and talk about. When and you see on the internet, or you'll even see in publications sometimes, that creditors, people you owe money to, can only recover from probate estates. Here's where it gets really confusing. When I say a probate estate, those are the assets that are going through a court process when someone passes away. Now, in Ohio, nothing you own has to go through probate. So if I've done my estate plan correctly, my assets are not going to go through probate, because when I pass away, I don't want my wife or my kids or whoever's inheriting my money at that time to have to pay my creditors. I want it to flow right on through to them, and I want it to be their asset. I don't want them to have to hire attorneys, go to court, get appraisals. I want it to be easy. Sometimes when I do presentations on estate planning, I'll ask, and if we were all in the same room, I would ask this: how many of you taking this presentation have an estate plan? Half the room would raise their hands, half the room wouldn't, and then I would say, surprise, you all have an estate plan. We either have the estate plan we create for ourselves, or we have the estate plan the government has created for us. The estate plan the government has created for us is the probate process. And that's a process that means when you pass away, every county has a county probate court that you go to. You have to have someone appointed as being in charge of the estate. And then any assets that need to go through probate are under that court's jurisdiction. They will require appraisals. They will have hearings. It will take months and months, but the assets will go through that probate process and then get distributed out to the beneficiaries. I'm guessing that more than a few of you have been through that process for one or more of your loved ones when they pass away. So the thing that makes it confusing is a creditor. So a creditor, again, being someone I owe money to, if I borrow $25,000 from my next door neighbor and then I die and he's saying, whoa, Derek died, I want my $25,000 back. He can only come in and try to recover that $25,000 from my probate estate. Most creditors, when someone dies, can only come after probate assets. They can't come after things that don't go through probate. So that itself creates a unique situation, because I can owe $50,000 on credit card debt, and my next door neighbor and my variety of other situation or creditors, I can owe them all this money. I can die. I can have $10 million in assets. I don't, wish I did. I could have $10 million in assets that pass to my kids and my wife outside of probate, and the creditors, they can't do anything about it. They can't sue my wife. They can't sue my kids. As long as my wife or my kids didn't obligate themselves on the underlying debt, they can only come after my probate estate. And so most creditors, when someone passes away, they can only come after the assets that go through court. And so one of the most common planning strategies for us attorneys is, since in Ohio nothing has to go through court, why would we let anything go to court? You don't need a trust to avoid court. You don't need even a fancy estate plan. There are lots of ways an asset can avoid court. Take, for example, a life insurance policy. If a life insurance policy has a beneficiary, it doesn't go through court. If a life insurance policy doesn't name a beneficiary, it goes through court. If your house has a transfer on death beneficiary that's been recorded with your county recorder, it won't go through court. If it doesn't, it will go through court. So there are simple steps you can take to make sure things don't go through court. But one of the sources of bad information out there is that when someone dies, Medicaid estate recovery can only come after assets that go through court. And unfortunately, that's just not true. When someone passes away, Medicaid estate recovery, they're them and in some situations the IRS are the only examples where a creditor can come after assets that didn't go through court. And so that means if I have a life insurance policy and I name my best friend at work as the beneficiary, thinking when I die, I'm going to surprise him and he's going to find out he's the beneficiary of my $100,000 life insurance policy. Then I pass away, he gets that money. He's going to think, well, this is great. Derek left me a gift, only to find out later, hold on, here comes Medicaid. And we'll talk about how this looks practically in a little bit. They want to be paid back out of those life insurance proceeds. They are going to say, here's a bill. Derek used a nursing home for 3 years back when he was dealing with that brain injury, and you owe us X number of dollars. And so it can really catch people by surprise sometimes. But the big takeaway I want you to have first is Medicaid estate recovery. It applies to any asset a person, or I'm sorry, any asset a Medicaid recipient had a legal interest in at the time of their death. So if you have a legal interest in this asset, then it's subject to Medicaid estate recovery. Now, so that's one thing. Don't get caught in the trap of thinking if it doesn't go through court, it's not subject to creditors. Here's the other thing I want you to be careful of. In Medicaid, when we start talking about Medicaid and Medicaid eligibility, we love to use the term countable assets and exempt assets or non-countable resources. We'll talk about countable resources, we'll talk about non-countable resources. This is very much an important distinction when someone is becoming eligible for Medicaid. You'll hear people talk about how a house is an exempt resource, and it is as long as you live there. If you're not living there, if you have an intent to return there. You'll hear people talk about how a car is an exempt resource. It is. You can own a car, use it for transportation, and it doesn't count towards your $2,000 asset limit. So when you're applying for Medicaid and you have that $2,000 asset limit that you're trying to stay in compliance with, they're looking at when deciding whether or not you have more than $2,000, what do you have that's countable? What do you have that's exempt? So I could have a house that's worth, $300,000, a car that's worth $25,000. I could have a burial plot that I paid $10,000 for and all these other assets, but none of those count towards the $2,000 limit. None of those are going to keep me from getting Medicaid. But if I have a checking account with $3,500 in it, that can stop me from getting Medicaid because that's a countable resource. This is an important distinction in Medicaid estate recovery because people think, okay, that asset was exempt. It doesn't keep me from getting eligible for Medicaid, so that's protected. It's exempt for purposes of getting eligible for Medicaid. It is not exempt from Medicaid estate recovery. So when we use the terms countable and non-countable or countable and exempt resources, those are terms that apply when we're determining eligibility. They are not terms that apply when we're deciding what the government can and cannot come after someday when the recipient passes away. And so going back to my slide here, let me back up a little bit. Take real estate. We had a situation several years ago here at my firm where husband and wife were married. They both retired. They were living off pensions and living in their home. They didn't have a lot in the way of savings. The husband had some neurological conditions, and he did end up living in a nursing home for a few years. While he was in the nursing home, his wife continued to live in their home, and that home is an exempt resource because his spouse lives in it. So they have their pensions. They kind of live paycheck to paycheck. He's in a nursing home. He passes away, and I didn't know these people at the time any of this was happening. He passes away. The wife lives another 15 years, 10 or 15 years after him, and then she passes away. And now the kids think, we're sad, mom passed away, let's sell her house, let's split up the money. And then in comes Medicaid and says, hold on a second, dad was an owner of that house 15 years ago, he used Medicaid, you owe us all the payments back for what was spent on his behalf. So that's an example of how an asset that at one point in time is exempt can absolutely be used to recover from later on when someone passes away. So, and we'll talk more about that in just a second. So the next thing I want to talk about is who is it recovered from? Um, it's recovered from anyone with possession of an asset subject to MER. Basically, those listed on the previous slide. So it doesn't matter if it's a family member, a friend, if as a result of my death, you receive an asset that I used to own and I was a Medicaid recipient, they, being the state of Ohio, can come after you to recover up to the value of what you received from me and apply it towards the cost of my Medicaid benefits that the state paid on my behalf. So it's really broad range in terms of who it can be recovered from, and that's part of what makes it scary. All right, let me get how much do they recover? So they're going to, when they come after you, the government comes after your estate or your assets. When they come after your assets after you pass away, they're going to seek to recover the balance of any funds paid for long-term care, Medicaid, HCBS, and some Medicare premiums. Now, I'm always hesitant to say Medicare because that can take people down a rabbit hole. A lot of Medicare benefits are not subject to Medicaid estate recovery. Your average mom dad situation where they're in their 80s and they're relying upon Medicare, that those benefits are not subject to Medicaid estate recovery. But some joint programs like MPAP and those kind of things do count towards your Medicaid estate recovery balance. And again, I've said this earlier on in the presentation, and I'll say it again. The balance of what is owed is always more than what the client expects. Clients never, in my experience, truly appreciate how much has been spent. And so one of the things I always try to do right out of the gate when I have a situation that involves Medicaid estate recovery is reframe expectations so people know, hey, we're going to find out how much is owed to Medicaid. It's going to be more than you realize once we get that number. Now, when do they recover? So when do they come in and try to recover these funds? They're going to come in and recover these funds after the death of the Medicaid recipient. So after the death of the Medicaid recipient, that's when they come in and try to recover these funds. Now, you hear people, I hear it in my own family, and it kind of drives me up a wall because I have people all day that call and they want to pay me for advice and that kind of stuff, but then you go talk to your own family and no one will listen to. And that's always been the case in every family I've been around. So you've got these situations where grandma, grandpa, they're getting older and they tell you, hey, I'm worried about what will happen if I go into a nursing home. And I try to ask them, why are you worried about that? Well, they're going to come in and take my stuff or take my house. And the government doesn't do that. They don't come in while you're alive and take your assets. They don't come in while you're alive and confiscate your stuff. What people are really saying is it's hard to get financially eligible for Medicaid, and I might have to spend down some of my assets to get to the point where I'm financially eligible. That's a little bit different, though. They don't come in and try to recover until after the death of the Medicaid recipient. And if the Medicaid recipient is married, they only come in and try to recover after the death of the spouse. So they're going to wait till after the spouse dies. So that's why that example I used a few minutes ago played out the way it did. Because the person that received Medicaid died, I think it was like year 2000, 2001. His wife died in 2024. Kids thought, okay, we inherited mom's house, and only to find out, no, dad had used Medicaid. And so here comes the state wanting to be paid back after the death of the spouse. So marriage, one thing to know about Medicaid estate recovery, it has a large impact on the timing of Medicaid estate recovery and the impact. A surviving spouse has certain planning options they can take advantage of. So if you do have a husband and wife situation, there are lots of things a surviving spouse can do to get assets out of their name so that it's not subject to Medicaid estate recovery in the same way after they pass away. A person who's actively receiving Medicaid can't just gift assets away. Because if they do, that gift is what's called an improper transfer, and they're going to disqualify you from Medicaid. But a surviving spouse who's not receiving Medicaid, but whose deceased spouse did receive Medicaid, they have more gifting and strategy options available to them to minimize the effects of Medicaid estate recovery. So, and I'm going to tie all this back to developmental disabilities and employment here in just a second. I'm just trying to give us the framework of Medicaid estate recovery as we get there.
Hey, Derek, there's one
Yes.
question that you might want to answer.
Okay, let me look.
So, if the death of a spouse is more than 5 years after the death of the recipient, does it then fall outside of the 5 year look back?
So the 5 year look back applies to transfers made prior to applying for Medicaid. So there's the 5 year period is not going to protect you from Medicaid estate recovery. So if the Medicaid recipient had a legal interest in it at the time of their death, and then 10 years later, their spouse, who was their spouse at the time they received the Medicaid benefits, then passes away, that starts the clock on when Medicaid estate recovery can occur. Now, that rule is very different in different states. So again, that's a question, and that's a great question that gives you an example of something where if you Google it, you will get different answers from different websites, and that's because that is a state by state situation. All right. So Medicaid planning for aging, again, it has a much more frequent impact because of spousal situations where one spouse might spend down assets to get eligible for Medicaid. It also has more impact because you have surviving spouses that may live, a long time, and Medicaid estate recovery is a much more common tactic. But it definitely comes up a lot in the lives of individuals with developmental disabilities as well. And one of the things about Medicaid estate recovery that does often bother me is we hear all the time from families that because of things like Medicaid estate recovery or what they might read online, that a person with a developmental disability should not work because they're just working to accrue benefits that are ultimately going to go back to the state. And while I cannot tell you that there's never a scenario that assets might not, make their way back to the state, there are lots of planning strategies and things that can be done that makes this a myth. It's not true. I'm a firm believer that Medicaid estate recovery itself is not something that should be impacting the lifestyle or the decisions made by the person with the developmental disability. For my own daughter, as she turns 18 and we start to pursue more transitions into adulthood, I don't know what the future holds for her, but I can tell you whether she works or doesn't work will have absolutely nothing to do with Medicaid estate recovery. It won't register in my mind at all. And so, again, that's not to say it doesn't have harmful effects sometimes. It does. But the benefits of employment and the benefits of that integration employment, I think, so greatly outweigh any negative impacts that come up from Medicaid estate recovery. Now, we talked about this Medicaid estate recovery, and what does it actually look like? So what does it look like when it really plays out? Well, it's a process that's managed by the Ohio Attorney General's office. So the Ohio Attorney General, they have an MER division. It's run by one attorney that's been there forever. Very good guy, very good at what he does, and he's very good to work with. What complicates it, though, is the Ohio Attorney General, they don't have enough attorneys to do all of this. So every time a Medicaid recipient passes away, they don't have the bandwidth to reach out and start pursuing, hey, were there assets in this person's estate? Does he have any assets subject to Medicaid estate recovery? So what the Ohio Attorney General does is they have a whole list of law firms that they subcontract to do debt collection on behalf of the state of Ohio. If you've ever fallen behind on some kind of debt, whether it be a credit card debt or something like that, and you get a letter from a collection firm, they have these notices and they tell you, hey, you owe this money, you do XYZ by this date, or we're going to file a lawsuit. And they have all that language in there about this is a debt collector attempting to collect a debt, blah, blah, blah. They have all this stuff they're required to say. The state of Ohio, those firms are just debt collection law firms. And the state of Ohio subcontracts with dozens of debt collection law firms. And so what they do is when someone that's a Medicaid recipient passes away, they will give that information to the law firm that does debt collection on behalf of the state of Ohio. And so, as a lot of you that are taking this class know, one of the ways I was able to get kind of involved in our developmental disability system and learn more about the developmental disability system is I'm the attorney for APSE. And for those that don't know, APSE is Advocacy and Protective Services, Inc. It's this guardian of last resort. APSE is the guardian statewide for like 3,000 individuals. And APSE is only ever the guardian of the person. But I would say about once every month or every 2 or 3 months, APSE gets a letter from a debt collector saying, hey, you were the guardian of, let's say, Johnny. You were the guardian of Johnny. Johnny passed away. We want detailed information from you as his guardian on what assets were in Johnny's name at the time of his passing. Please provide us his bank statements. Please provide us with a list of real estate he owned. Please provide us with all this stuff. Now, APSE always sends the same form letter back saying, sorry about your luck. APSE was guardian of the person only. We don't control any of his assets. And to our knowledge, he didn't have any assets. And so that's what happens the vast majority of time. But if we did know of an asset, we would have an obligation to report that back to them. Now, this is where M.E.R. for a lot of individuals with developmental disabilities, it's not going to come into play that much because by virtue of staying eligible for SSI or Medicaid waivers, we do have those harsh asset limits we have to comply with. And even if you're in Medicaid buy-in or some of those programs, you still have pretty harsh asset limits you have to stay within in compliance with. And so by virtue of staying eligible for those, it's not that common that someone has assets that are collectible when they pass away, but it absolutely does happen. So when someone passes away, Medicaid Estate Recovery, and when Medicaid finds out, and Medicaid finds out through the billing and through you, the developmental disability system, you report their death, their Social Security ties all this together, and that's what triggers the Ohio Attorney General sending this out to a debt collector. Now, the debt collector, they have the discretion to just say, you know what, Johnny had a profound developmental disability. We know he didn't have employment. We have no reason to suspect he had assets, and we're going to drop it. And so a lot of debt collectors do. It's not worth their postage to pursue even those letters. And so I am not at all saying that every time someone with a developmental disability passes away, this happens. It's more sporadic and random. And if they have a reason to believe someone had assets, they will go after it. But it doesn't happen in every situation. But guardians, friends, family, next of kin, they all may get letters someday from a debt collector saying, hey, you had this relationship to Johnny. Johnny passed away. Johnny was a Medicaid recipient. Now we're here to try to collect and recover what Medicaid paid on Johnny's behalf. The Ohio Attorney General and the debt collectors doing this, if someone does have an asset, they typically are pretty good about negotiating with you. In other words, if Johnny does have a house and he lived in that house is now subject to Medicaid Estate Recovery. And so Johnny's sister may have thought she was going to inherit that house when Johnny dies, only to find out that because Johnny had a developmental disability, used an IO waiver, he's got all this money he owes back to the state of Ohio, and Johnny's sister might not be getting that house. And so the Ohio Attorney General will typically negotiate some. And when I say negotiate some, I don't mean they're going to say, let's split it down the middle. They negotiate pretty toughly, but they will carve out some funds for surviving friends and family members. And I'll talk more about this in a second. They carve that out really based on how cooperative the family was and how many hoops you make them jump through to pursue the asset. In my experience, if someone truly has an asset that is subject to Medicaid Estate Recovery, your best course of action by far is to be very transparent and cooperative with the Ohio Attorney General. And that has always yielded much better results for my clients as opposed to trying to be coy or hide something. That never works. Now, this gets me to another myth I hear all the time. Sometimes I'll meet families, and you've all met these families too, where they don't want to accept services. Maybe they have an idea that the government is bad, and that you as part of the DD system are bad, and that if they do accept services, they've heard about this Medicaid Estate Recovery, and the parents or family think that they're going to have to pay back out of their funds. And so this is another myth I want to make very clear. The only assets from which Medicaid expenditures can be recovered are assets that were owned by the person with a developmental disability. So in my daughter Megan's lifetime, let's say she receives $500,000 of Medicaid services and then she passes away. Medicaid Estate Recovery, they can come in and say, what does Megan own? And they can recover from Megan's assets, but they will never and can never send a bill to my wife and I saying, hey, Derek and Katie, you owe us $500,000. My money, my assets are not at risk of recovery. And so Megan's um, Megan's assets will pay Megan's expenses, not mom and dad's assets. So I'm not at risk because one of my children receives Medicaid benefits. And that is a myth we hear a lot, where sometimes there's concern that, hey, if I let my daughter receive SSI, they're going to come after me for that someday. Or if I let my child get a waiver, then someday they're going to want me to pay this money back. That is not true. They only try to recover from the person with the developmental disability.
Derek, there's one question. Deborah asked if children get Medicaid benefits on their parents' Medicaid account, will Medicaid come after those children's assets later in life when they're adults and pass?
Okay. Another clarification point. Most of the time in questions like that, when somebody says, if children are receiving Medicaid on the parents' benefits, and I have no idea what the specifics are of this situation and don't need to, but one thing I do want to clarify, Medicaid has become a lot more confusing because we have so many different types of Medicaid. Normally, when you get that question, it's from someone who has purchased or not purchased, has applied for and received Medicaid coverage through the exchange. And um, expansion Medicaid, also known as Obamacare, it is not subject to Medicaid estate recovery. Now, I say that with an asterisk because technically at the federal level, they've never strictly said it's not subject to Medicaid estate recovery, but it's never been pursued for recovery. And the general legal belief is if it were, it would not be subject to the federal mandate. So if I go out, if my wife and I, we lose our job and we go out on the exchange and we qualify for expansion Medicaid based on our household's income, and we have Medicaid coverage for myself, my wife, and our kids, that doesn't mean I've now saddled my kids with their assets are going to be subject to Medicaid estate recovery someday when they pass away. As minors, the only recovery would be of the parents' assets if you even found that expansion Medicaid was subject to recovery, which generally speaking, it is not. And I say that with an asterisk because anyone tells you that there is some gray area there that's open to interpretation. But so far, it's always been interpreted very friendly towards not pursuing recovery. If a minor child has a Medicaid waiver, then that money is counted for Medicaid payback purposes, which we'll talk about in a second, not Medicaid estate recovery. One of the things about Medicaid estate recovery, and I'm hesitant to get into this because it makes it really confusing, but generally speaking, Medicaid estate recovery only kicks in for assets, is only subject to assets for benefits you receive after the age of 55. Now, what makes that very confusing, and don't rest on, okay, so if I have my 25-year-old has a waiver, we're in the clear. There's two different things that apply here. There's Medicaid estate recovery, which is recovering assets when someone passes, and then there's Medicaid payback. And those are two different concepts that we'll talk about and actually the next slide. So
I'm sorry, Derek. There's several questions, but I'm trying to give them to you when you're talking about a specific area.
Okay.
So Bob says they do try to collect the ACA recovery.
Okay. There are some circumstances where they can, but generally speaking, that's news to me. And then a slightly different version of that question. What about children who receive Medicaid due to being in foster care and kept that Medicaid through 18 years of age? That I don't know the answer to. All right. The next thing I want to get into is Medicaid estate recovery versus Medicaid payback. with Medicaid estate recovery versus Medicaid payback, this is a little bit of a difference. And Medicaid payback is something that's much more prevalent and relevant to individuals with developmental disabilities. And for Medicaid payback, this is when we get into a difference of first party assets versus third party assets. So if Megan, my daughter with Down syndrome, if she has assets that are in her name that she has a legal interest in, that is a first party asset. And they are going to consider that asset when determining whether or not she is eligible for Medicaid benefits. And so, one of the things that can be done with first party assets is you can move them into a stable account, which we'll talk about in a second. You can create a first party special needs trust. You can also have other ways that you can spend that money to keep it from being deemed an eligible, keep it from being deemed accountable resource. So first party assets are assets that belong to the person with the developmental disability. And so examples of those are wages from employment, Social Security benefits, proceeds from a lawsuit, retirement accounts that accrue during someone's employment, certain unplanned inheritances, and just other assets titled in the name of the person with the developmental disability. The problem with first party assets is they keep you from getting eligible for Medicaid. And so going back to 1993, in that ominous Budget Reconciliation Act of 1993, Medicaid made a deal, or the federal government made a deal with Medicaid recipients. They said, okay, Megan, I'll use my daughter as an example. Let's say she's got $20,000 that she wins in a lawsuit. Or let me change it. Let's say she has $50,000 she wins in a lawsuit. So I'm driving her somewhere. We're rear-ended by a drunk driver. I'm mad at that drunk driver, so I sue that drunk driver because Megan's been injured. We win $50,000 in a lawsuit. That $50,000 belongs to Megan. At that point, that's a first party asset, and Megan can't have more than $2,000 in assets or she's not going to be eligible for her Medicaid benefits. One of the things I can do is I can take that and I can put that money into a stable account, but stable account is tough in that situation because you can only put $20,000 a year in a stable account. Or I can put it in a special needs trust, and that's a Medicaid payback trust. And so now I've taken a first party asset, if I put it in a special needs trust, and I've converted it to being an exempt resource, because money in a special needs trust is an exempt resource. But a special needs trust, the deal that was struck in 1993 in that Omnibus Budget Reconciliation Act is, okay, Megan can get that $50,000 and she can put it into a special needs trust, but someday when she dies, money left in that special needs trust has to be used to pay back the state of Ohio for the benefits she received during her lifetime. So when I create a special needs trust that holds first party assets, assets that truly belong to Megan, and I put those into that trust, that does protect her eligibility for benefits, but it is going to be used to pay back the government for what they've paid on her behalf when she passes away. And so now when Megan dies, I'm back to contacting the Ohio Attorney General. They'll tell me exactly how much money they've paid on Megan's behalf. And then at that point, they will try to recover that amount from the special needs trust. So special needs trusts that hold first party assets, sometimes they almost feel like they put a black cloud over the individual's life because you have this money, it's set aside, it's saved. You want it to be used for purposes that make their life better, but you also worry because you know that when the person passes away, that money is going to go back to the state of Ohio. And so it is important that when you have a special needs trust that is truly a Medicaid payback trust, that you think about that money and think about how you want to use that over the course of the individual's life. The special needs trust Medicaid payback component is not subject to that age 55 rule. So you can be any age and receive a Medicaid service, and it is subject to Medicaid payback for funds that are in a special needs trust. So that's another area, and frankly, that's a much more common area where we deal with Medicaid is not necessarily Medicaid estate recovery, but Medicaid payback of special needs trust funds. Now, stable accounts, I'm a huge fan of stable accounts. When they were first created, stable accounts were made subject, they are always subject to Medicaid payback at the federal level, but the state of Ohio also made them subject to Medicaid payback. Last year, as part of the state of Ohio's budget bill, they eliminated the state payback requirement for stable accounts. And so, stable accounts, one of the things that's not necessarily great about a stable account, and again, I'm a huge fan of stable accounts. They're a wonderful tool that people should know how they work. Stable accounts cannot designate a beneficiary, a death beneficiary. When you pass away and you have a stable account, it has to go to probate court. And then once it goes to probate court, the federal Medicaid estate recovery laws remain in place, where the federal government requires the state to come after Medicaid estate recovery. And so that means if you're 55 and older and you have a stable account, services you received after the age of 55 that are in that stable account will be subject to Medicaid estate recovery. If you're 35 years old and you have a stable account and you pass away, that money will have to go to probate, but will not be subject to a Medicaid estate recovery. And so it's a big win. And the state of Ohio, to their credit, has done everything they can possibly do to eliminate or reduce the estate recovery component on stable accounts. Unfortunately, the state of Ohio can't get rid of that federal mandate that does still impact stable accounts after someone reaches the age of 55. Now, another area where we always try to clarify things, third-party assets, these are assets that don't belong to Megan. So as my wife and I, we want to do an estate plan for Megan, we certainly can. We can leave money to Megan in a specific type of trust that's called a discretionary trust, or sometimes you'll hear supplemental services trust. For this type of asset, there is no Medicaid estate recovery. So as long as this is set up correctly and done correctly by an attorney, this trust that I leave behind inheritance for Megan, it can be used by Megan for any variety of reasons. And then upon Megan's passing, nothing gets paid back to the state of Ohio out of this trust. The leftover money will roll back to my other kids or whoever I've designated. All right. Impact of having a power of attorney, guardian, supported decision-making. While decision-making supporters can assist with planning to minimize the effects of Medicaid estate recovery, they will not have any impact on what happens after someone passes away. So sometimes people say, hey, as so-and-so's guardian, what can I do to not have to pay back money? Whether it be in Medicaid estate recovery or Medicaid payback, what can I do? Unfortunately, once the person passes away, the worst thing you can do is try to hide or maneuver assets so they don't get found by the Ohio Attorney General. That itself is a crime and not a road you want to go down. I also get questions sometimes that say, all right, well, if all this happens, can the person with the developmental disability have a will or some other estate planning tool that will prevent the Medicaid payback or will prevent the Medicaid estate recovery? I'm a big fan of people with developmental disabilities creating their own estate plan. I think that is a wise and prudent thing for them to do. Unfortunately, they're not going to be able to do anything as part of their estate plan that eliminates or stops the Medicaid estate recovery from taking place or stops the Medicaid payback component from taking place. That is unfortunately going to happen. Yeah. So also get the question of Medicaid estate recovery and the impact on Social Security funds. A minor amount of Social Security funds can be taken back at someone's death, not that often. Most remain in the person's estate. Social Security funds that remain in the estate, meaning they were properly received during the lifetime, they can be carried forward into the person's estate, and those funds can be subject to Medicaid estate recovery. Now, and they could also be subject to Medicaid payback. If the only assets are that rep pay account where they were doing what they were supposed to do and they were keeping the balance below $2,000, I'm not aware of any situation where the Ohio Attorney General has come after that low of an amount of money, because in order to come after it, they would force the person to put those funds into a probate estate, and the cost of administering the estate would greatly exceed the cost of anything they might recover. But if you have a house you were living in that your mom and dad left you, and You also have a Rep P account that has a little bit of money left over that can be pulled into your probate estate, depending on how it's set up, and that can be made subject to Medicaid estate recovery. There are some exceptions to Medicaid estate recovery, and I know we've got some questions, and I'm going to get to those in just a minute. Some of the exceptions to Medicaid estate recovery, you've got, first of all, a spouse. So there's no Medicaid estate recovery until your spouse passes away. There's no Medicaid estate recovery if you have minor children at the time you pass away. The other one that comes up a lot is if you have a child or a loved one with a developmental disability, then a parent can transfer assets to a child with a developmental disability. And that is not an improper transfer if the parent is doing Medicaid planning. Now, let me explain what I mean by that. This doesn't really help the person with the developmental disability avoid Medicaid estate recovery. What it does is it helps the parent. So as I said, I've got a little bit of a family history of Alzheimer's. So I get older, I get diagnosed with Alzheimer's. I can't just gift money to my kids, or that's considered an improper transfer. That can stop me from getting eligible for Medicaid. What I can do is I can gift assets to Megan, and if I do that, it's going to make me eligible for Medicaid. It's going to make her ineligible for Medicaid. Or there's a specific type of trust I can create where I can transfer assets to Megan in a very specific type of trust where it's now available for her benefit. It will not interfere with her eligibility for benefits. The money is now Megan's money in that trust. I, as the parent, can become eligible for Medicaid. It is not an improper transfer, and I have not messed up Megan's eligibility for Medicaid. That's a really tricky, nuanced situation to get into. But it does come up from time to time. The other thing to know about Medicaid estate recovery and Medicaid payback is there is a hardship provision. If the Medicaid estate recovery is going to leave someone in a really bad spot, if somebody was living with a sibling, and again, if you're living with a sibling, there's some special rules for that situation too. But there's a hardship waiver that can always be applied for. It's generally a pretty high standard to get. But you can always ask the Ohio Attorney General to consider a hardship waiver if the Medicaid estate recovery is going to leave a loved one in a really precarious or tough spot as a result of someone's passing. So don't be bashful or afraid to apply for that hardship waiver if someone is their estate is facing Medicaid estate recovery, and that's leaving a family member or friend who relied upon them in a very difficult or tough spot. One of the big takeaway from Medicaid estate recovery that I always tell people is Medicaid estate recovery should be understood, and it may factor into some basic planning, but it should not be a factor in whether someone with a developmental disability seeks employment. I honestly, you would have a really, really hard time coming up with a fact pattern of any kind for me where I would say, yeah, don't pursue employment. Employment does have an impact on some benefits, but given what I do, working with families, just about all the programs, and I was so glad to see the other people that have already spoke, or the topics that have been covered, rather SSI and SSDI, most of those programs, some better than others, have work incentive programs that encourage people to try employment. And so while Medicaid estate recovery is something that should be understood, and it is something that can sometimes frustrate people because an individual with a developmental disability that does work their whole life and does accrue assets, and maybe they do have retirement accounts or things of that nature, and they want to make sure those funds go to their loved ones of choosing, just like all of us want, they can sometimes be made subject to Medicaid estate recovery, and that is harsh. One other takeaway before I open it up for questions, and this is my big pet peeve that I say all the time in presentations, but it is one area where I think as a developmental disability system, we fail a lot of the self-advocates we're supposed to be serving. When in a lot of us, it is natural that when we have money, we want to save the money, and saving money is really important. But when you have an asset like a special needs trust that's subject to Medicaid payback, or if you have an asset that is subject to Medicaid estate recovery, and I say this all the time, especially with stable accounts. Stable accounts were created because we didn't want people frivolously spending money. But my big pet peeve that has really developed over the last 10 years is we don't ever spend it. And so as a team, when we're supporting someone, or if we're someone's, supporter through decision making or something of that nature, we need to be encouraging them. What are we saving the money for? What is our goal? What's the outcome we're pursuing by saving all of this money? It does me no good to sue someone, win $50,000 in a lawsuit for Megan, and then tell her she's never allowed to spend the money because I want to save it for a rainy day. Because when she passes away, I'm going to write a really big check to the state of Ohio. And so I always encourage clients when they're a trustee of a special needs trust and the person wants to spend money to take a trip or do something fun, the answer should always be yes, let's do it. Let's spend the money. It's counterintuitive. I've been accused in my lifetime of being frugal. I don't like to spend money either. But you know what I really don't like? Watching clients write large checks to the state of Ohio. So when you have assets and you have savings and you have special needs trust, if you're part of a person's team and they've got $25,000 in their stable account, my question to you would be, what for? I'm on the committee of stable. I don't not try to toot my own horn, but I'm one of the people that was appointed by the governor to kind of oversee stable accounts and on this committee. And one of the things that I asked them to start providing us at our quarterly meetings is I don't want to know how much money was saved out in stable accounts. I want to know how much money was spent this quarter out of a stable account. And with stable accounts especially, we save far more money than we spend, which again always makes me wonder, what are we saving it for? So this is my soapbox. It's my pet peeve. As you're working with clients, encourage them to spend the money. Okay, I do. I'm going to open it up now for questions, and I'll start scrolling through the chat and try to answer questions. I also have to warn everybody, I have to jump off at like 2:25 or so. I have a guardianship hearing right after this that I've got to jump on. But I really enjoy this topic. I'll never claim to be an expert on everything that's covered under this presentation because honestly, nobody is. Nobody deals with Medicaid estate recovery all day, every day. But certainly, I hope you found something useful in all of this. And so while I start answering questions, I am going to switch to this slide so you can all be putting on your calendar when you should be coming back next for the next presentation.